Here we go, aggravated stalking. Not harassment, not bothering someone, but one of the most serious personal safety crimes Michigan has. Judges take these cases very personally because stalking ruins lives quietly. Quick question to viewers. Would you show up to sentencing if you were terrified of the defendant?
People of the State of Michigan versus Brandon Lee Thomas, file number 24-7175FH. Time and date set for sentencing. The defendant is present, represented by attorney Michelle R. Siv. People are represented by assistant prosecuting attorney Alexander Pani. On February 24th of this year, the defendant had pled guilty to aggravated stalking. Mr. Nathan Licht has prepared the pre-sentence report dated March 21, 2025. Ms. Siv, have you and your client had the opportunity to review the pre-sentence report?
Yes, we have.
Are there any additions, deletions, corrections, or objections to the report other than guidelines?
Yes, Your Honor.
What would you like to say on behalf of your client before the court imposes sentence?
Thank you. I had a chance to go over the recommendation with Mr. Thomas. I guess the court to adopt most of the conditions with the exception of the jail time. 9 days recommended, but I would ask for the court to consider if there's a different way to go about that due to Mr. Thomas being, he owns his own lawn and snow care business. So in regards to his employment, that's the only way, that's the only income source, and he provides for himself and his family.
The defense is trying the my client has responsibilities angle. Business owner, 2 kids, no prior felonies. Classic mitigation strategy. But judges will always balance livelihood versus public safety. Should employment matter when sentencing a stalker? Drop your thoughts.
And his family has 2 minor children who he cares for wholly all on his own. The mother, unfortunately, is not involved. Does not have any prior felony convictions. This, unfortunately, will be his first. But in regards to anything else, again, I would strongly ask the court to consider a way that Mr. Thomas can continue his employment. He does have contracts that are.
Mr. Licht, it's prohibited by statute, correct, regarding work release.
I don't think it was statute. I think it was
It's the memo of the court. Okay. Okay, thank you. Does your client wish to address the court, Ms. Siv?
No, it might be no contest, Your Honor.
All right, thank you. Mr. Pahani, anything to be happy?
Yes, Your Honor. I would note, just for the record, that the complaining witness is not
Huge
present.
detail. The victim didn't show up because she says there is literally no safe place for her in the county. That's not just fear, that's exhaustion mixed with trauma. And now the prosecutor drops the bomb. The stalking incident happened inside the courthouse. You cannot ask for better narrative setting.
The complaining witness is not present in court today because she is terrified of this defendant, Your Honor. There is no safe place in Huron County for her because, as the court may recall from the factual basis placed at the no contest plea, the final incident that resulted in Mr. Thomas's arrest by the Bad Axe Police Department occurred in this very building. So she doesn't even feel safe coming here to speak to the court directly about the effect that his behavior has had on her over this course of stalking. Now, Your Honor, that's a word that gets thrown around a lot, stalking and stalkers, but in this particular case, it fits the bill perfectly. What this defendant did to his ex-wife is disturbing at best. As soon as she filed for divorce from him, he immediately on the same day goes and files a mentally ill petition in the probate court, has her picked up by the police and taken to Schur Hospital for a mental evaluation because he just can't believe that she's filed for divorce from him. She's immediately cleared from Schur Hospital, but that's not where it ends, Your Honor. She wonders why everywhere she seems to go in Huron County when she's out and about with her friends carrying on her normal daily activities, he seems to show up. And she can't figure it out until, at one point,
GPS device reveal, and not some tracker you get on Amazon. Hardwired, powered by the vehicle. Years installed, then reactivated after divorce. If this was a Netflix documentary, this is the moment the dramatic music kicks in. Viewer question: should installing any GPS without permission automatically be a felony?
At one point, she takes her car to a mechanic for service, and he finds a GPS tracking device installed in the vehicle. Now, he's indicated to the police that he puts that on all of his snow removal equipment and all of his vehicles, and it turns out that it had been installed on her vehicle for years. It hadn't been activated until such time as she filed for divorce, and he reactivated the account so he could know exactly where she was. And Your Honor, we're not talking about an Apple AirTag or something that one puts into a vehicle. We're talking about a hardwired device that was wired into the vehicle's power so he could know where she was at all times. And that's how he knew how to show up wherever she was, whatever she was doing. There was Mr. Thomas, a true stalker in the very definition of the statute. Your Honor, the recommendation from the Department of Corrections in this case is appropriate. Mr. Thomas does need to go to jail for 90 days, and he does need to be supervised for 5 years because his activities indicate that this breakup is something that he can just not get over. And the people are frightened as to what he might do if he is not on constant supervision. But the 90 days in jail, Your Honor, are going to be a wake-up call for Mr. Thomas in that when somebody breaks up and a relationship ends, that means it's over. And you can't just keep pushing for it. This is appropriate, Your Honor, and we ask for the court to institute it as written.
Does have any other?
Your Honor.
I'm sorry?
She is in the court.
I am here, and based on what I've heard, I would like to say something.
Please come forward, miss. I didn't see you back there. I apologize.
When the victim speaks in court, everything changes. Her testimony hits harder than the legal arguments. Confronting her boyfriend, contacting her family, showing up at random locations, following her car. This isn't checking in. This is obsession. This is escalation. And the scariest thing, she says?
I'm right over here. Your Honor, this is Danielle Slater, for the record.
Ms. Slater, go ahead.
I really am not comfortable doing this, but based on the fact that this man comes here and lies every single time we are here, this has not stopped. But it's things that the police cannot do anything about because he's going to other people. My boyfriend is here. Mr. Thomas aggressively confronted him in a gas station parking lot, threatening to get him banned from the premises. He went to my coworker's other job when my coworker wasn't even there, and when he went there for work the next time, everybody in the building knew who I was. They all knew that he was my ex-husband. They all knew all of this information about me, and he was allegedly there for a birthday party. He tried to make contact with my mother, my sister, my cousin, my best friend's husband, because he knew that I was at her house. He watched me pull down into the road she lives on. There's 3 houses on this road. And hours later, he's sending her husband a friend request on Facebook. All within the last couple of months. 2 weeks ago, he followed me home from Caro, pulling a trailer. Instead of, I'm going 45 miles an hour, trying to drive carefully. Instead of doing the speed limit and going around me and going on about his day, he hung back, following me. This has not stopped at all, and these are just the things that I have caught him doing. This is not going to stop. I came here last summer during one of the numerous hearings he called to terminate my PPO because he just wasn't doing anything wrong, and told you that he was publicly going around telling people that he would not stop until a judge made him, and I am asking you, please make him stop. Because this is not going to end. He could go to jail for full max sentence and have 10 years of probation, and I almost guaranteed you he will be on my doorstep the day that he is free and clear. This has not stopped at all.
Are there any children in common?
No.
Okay.
And I honestly have sent my son to live with his father, that I'm really not even comfortable with that, because he has numerous times tried to take my child from me, and it's not even his kid.
Anything else?
No.
Thank you.
Thank you.
Your Honor, with that in mind then, and I apologize to the court for representing that Ms. Slater wasn't here. I didn't see her go into the back of the courtroom. But with that in mind, Your Honor, I would mention that Ms. Slater has made those reports that she mentioned to the court, to the pretrial services officer, about Mr. Thomas appearing in other locations, having a confrontation with her boyfriend in the city of Cass City. Those reports were made to law enforcement and turned over to the pretrial services officer. But Again, law enforcement's hands are tied because he's not making direct or indirect contact with her in their estimation, but it continues and it's not going to stop until this court makes it stop.
Let's see if any other.
Just in regards to Thomas's conduct, I think that his behavior on bond, well, that he is doing what he's not contacting her. I think a lot of the things that were mentioned was very speculative in regards to what he may or may not do at the end of all of this. As the court is aware, I mean, there were issues with having that PPO in place for both sides, even on the victim's side as well. She was doing things that would contradict in regards to what was in the PPO, and there was actually a hearing on it, and the court somewhat basically ordered them to just stop, knock it off. So that was towards her as well, it wasn't just towards my client. So I was supportive for that too.
All right, thank you. Defendant has no prior felony record. He has 5 prior misdemeanors, age 42. Gainfully employed, doing his own work, which is admirable. And was in a relationship, married to someone where it just didn't work out. And if it doesn't work out, especially if there are no children in common, the whole idea is to go their separate ways, move on from it, learn from it. That's the end of it. That's not what happened here. The court does recall the PPO that this court authorized and the hearings that we've had subsequent to that. And the whole idea was there's a valid order in place, just stay away. That's what it comes down to. Now, the court is not aware of any alleged contact over the last couple of months. If it was reported to pretrial services, it wasn't reported to the court. But the court can certainly consider that as well. But at the end of the day, again, I'm not making light of this, but remember the old song, well, it's old now, I guess, Disney theme, let it go.
Absolutely.
Let it go. There is no relationship anymore. There's no contact. There's no nothing. You see her, you walk away. And that's what you have to do moving forward. Now, what is troubling to this court is it's one thing to show up and maybe track someone on their iPhone, or friends are saying, hey, look, she walked into the bar, or he walked into the bar, whatever the case may be. But you took the approach of actually installing a GPS device on the vehicle, which, again, is unheard of, frankly.
Your Honor, Your Honor, I apologize. In regards to that tracker, just so the court is aware, the device was previously on the vehicle beforehand. It was just reactivated.
I'll accept that, but reactivating it is the issue.
Your Honor, I would note that Ms. Slater informed the police agencies that she changed vehicles during the course of this tracker having been purchased and installed in the vehicle. She owned a different vehicle at the beginning of their marriage where it was installed. Then she purchased a new vehicle over the course of their marriage where it was removed from the previous vehicle and reinstalled in the vehicle that it was found in. Just to clarify the record.
It doesn't matter to the court. A GPS device is a GPS device, and it was utilized, and which caused the problem. And clearly, we have a victim in this courtroom that is terrified of this individual. That's just the way it is. And it comes down to, again, let it go.
The judge is now in full final lecture mode. Pay attention to the conditions. 5 years probation, no tracking devices, no contact through any person, 500-foot distance rule, and 270 days jail with 90 up front. Then the judge drops the simplest, truest line of the entire hearing.
Let it go. Walk away from it. Considering the defendant's history, considering all the factors in this case, it will be the sentence. This court that the defendant be placed under a mandatory term of probation for a period of 5 years. It's required under law. 5 years probation. Conditions of probation include the standard conditions: not to violate any criminal law of any government, not to leave the state of Michigan without prior approval to court, notifying the probation agent at least monthly or such times and places the agent may require, no alcoholic beverages consumed or possessed, nor enter bars, or where the primary purpose is to serve alcohol for consumption on the premises. Comply with requirements of alcohol and drug testing and following all the directives. No use of or possession of controlled substances unless prescribed by a licensed physician. Can't be around anyone that possesses those items or possesses drug paraphernalia. You cannot possess drug paraphernalia. You are to complete any mental health, domestic violence, battery intervention, or other recommended treatment following assessment by a qualified community-based service provider. Waive confidentiality to allow any treatment program required to attend and disclose the information to the agent. You are to comply with the DOC's electronic monitoring program as directed by the agent. Here's the significant one. No verbal, written, electronic, physical contact, either directly or through another person. So you can't channel through a neighbor, a friend, anyone. No contact, nor are you to be within 500 feet of her residence, school, or place of employment. Finally, regarding the jail time in this matter, the guidelines in this matter are 0 to 9 months. The court has to consider the guidelines. The court will sentence the defendant to serve 270 days in the county jail, credit for 2 days previously served. The first 90 days minus the 2 must be served up front. The remaining jail time will be held in abeyance pending successful completion of probation. Regarding work release in this matter, I cannot carve an exception out in this circumstance. I'm sorry, but the court has to follow and stay consistent no matter who you are or where you come from. Work release is not authorized in this matter. However, PA 511 programming otherwise is. Bottom line, Mr. Thomas, the old phrase, lose the number, no more. Stay away. It's my duty to inform you of the right to seek leave to appeal. If you're financially unable to provide counsel of your own choice, the court will assign counsel for you at public expense. Please initial the receipt questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court today. Remain in custody of the sheriff. That'll be all. Thank you.